Oh, okay. Okay. Oh, okay.
Good morning to all dignitaries, guests, and professors and students. I feel privileged to extend my warm welcome to all present here for the Justice E.Venkatesam Endowment Lecture. Let us begin this enriching experience with the hope that each one of us takes away something fruitful from this lecture. I would request all the dignitaries for the afternoon to please take the stage. I would request our Honorable Chief Guest, Justice Somayajalu, Guest of Honor, Shri Malak Puchu, our Honorable Vice Chancellor, Sir, Shri Dr. Surya Prakash, and our Academic Director, Dr. Dayanand Murthy, to please take the stage. Can we have a huge round of applause for everybody? Light is to darkness what courage is to fear. In the presence of one, the other disappears. Light is a symbol of brightness and prosperity. To make this afternoon a blessed one and to seek the blessings of Almighty, let us kindle the lamp of learning and wisdom. To further the same, I would request all the dignitaries to please light the lamp of learning. I hope the lighted lamp enlightens every soul in this hall. Moving further to seek the blessings of Almighty and to further the saying of even the most feeble prayer makes a difference, I would like to call upon Miss P. Sahita for a short prayer. I request everyone to please rise for the prayer. तुषारहार धवला या शुभ्रवस्त्रान्विता या वीणा वरदण्डमण्डितकरा या श्वेता पद्मासना या ब्रह्माच्युता शङ्करप्रभृतिभिः देवैः सदा पूजिता सा मां पातु सरस्वती भगवती निशेष जाढ्यापहा निशेष जाढ्यापः। Thank you for the soulful rendition. I would now like to call upon Ms. Siddhika to introduce our Honorable Vice Chancellor.
Thank you, Aditi. Our Honorable Professor Dr. S. Suryaprakash Sir, who is the Vice Chancellor of DSNLU, took in charge as the Vice Chancellor in the year 2018. He has more than 30 years of experience in academics. Before he joined, he was the Vice Chancellor of NLU Aurangabad and worked as a professor of NLIU Bhopal. Prior to that, he was the principal of DNR College of Law, AP, and a faculty member of NUJS. Sir has been a prolific writer as he has published several articles and chapters in reputed journals on contemporary issues like bonded labor and social justice that was forwarded by Honorable Justice M. Jagananda Rao. He has also edited books on critical issues on international commercial arbitration and mediation. He has presented more than 30 research papers in various national and international seminars and conferences, and has dealt with projects on interstate migrant labor, health laws, and so on. Sir's areas of interest include alternative dispute resolution, international commercial arbitration, labor laws, and health laws. Currently, he is the chairperson of the Center of Alternative Dispute Resolution, DSNLU. Thank you.
With this, I would like to request our Honorable Vice Chancellor, Sir, to please propose the welcome address.
Good morning to all. Honorable Justice Sri BVSS Swamiyajulu Garu, the person instrumental behind this event, today's event, Sri Ucha Malik Garu, and he has been pursuing me to conduct this program for the last 3-4 months. When I was in US, when I was here, constantly calling and fixed their tour to India, and he wants that during his visit to India, the program should be conducted. Thank you, sir, for liberally, generously donating an endowment fund of 22 lakhs to this university for endowment lecture in the name of Sri Justice E.Venkatesam Garu, a gold medal and another 2 gold medals. So our Director Academics and Research will give the more details. Sir, I think that your dream is materialized, and he insisted me. Thank you very much for blessing the university. My friend Dr. Dayanandamurthy, Director Research, invited guests, family members of Sri Justice Venkatesam Garu, learned faculty members, and my dear students. Today, it is a very auspicious day because today we are going to have an endowment lecture in the sense that earlier we had, but this is a true endowment lecture in the sense that in the name of Sri Justice E. Venkatesam Garu, who will be introduced to you by our members, and to say very briefly, he is an eminent jurist, judge, and a law teacher during those days. And it would be very difficult to compress an epic into an epigram because of his services to the Indian judiciary, particularly to the state of Andhra Pradesh. I would like to tell you very briefly, because I know that all of us are anxiously awaiting the lecture of Endowment Stalwart Sri D.S.N.L.U. Garu, and we are very fortunate that at a very short notice means very, very short notice, he has agreed in spite of his busy schedule. No, you know that how the work is progressing and every day he is on the bench. So coming back to Honorable Sri Justice E.Venkatesam Garu, a best known personality from Visakhapatnam, and he practiced here, born in the year 1908. He completed his law graduation from Madras Law College, and because the profile of E.Venkatesam Garu will be introduced by our students, here I am tempted, being a great jurist, and what the qualities of a judge and realistic to the situation. There are two cases, just because there are a number of cases which he has dealt. I would like to refer only two cases regarding the contempt of court. So in one case, he has punished, he imposed a fine, and in another case, he accepted an apology for contempt proceedings, and there is noted difference. In the first case, it was the client who has abused the judicial officers. There is the sessions judge and the trial judge. He filed a suit against the judges, and because there was some reason, and he was harassed by the tax officials, and at the time when he was produced before the court, he was 92 years old. 92 years old. Though he was 92 years old, but Justice Venkatesam Garu, he has noted that the contempt is not mere the physical structure of the court, but he has abused the judicial officers. And the lower courts has imposed 6 weeks imprisonment and 200 rupees fine, but he was reluctant to totally acquit the 92 years old accused, but said that keeping in view not imposing the sentence, but letting off with 200 rupees fine. This is regarding the contempt of court. And in another case, the petitioner who approached the High Court, he abused on a particular judgment, and he tendered an unconditional apology to the court. So, Honorable Justice Venkatesam Garu, with a generous heart, accepted the apology when he has, by mistake, out of ignorance, he has criticized the court and the judgment, and he was acquitted. What I mean to say is that in both the cases, it was contempt of court. But in spite of the age, that means he shows his judicial etiquette and the judicial mind. Where one has to be punished, he must be punished. Where one has to be acquitted, he should be acquitted. He has a generous heart. And there is a very, as I said in the beginning, that it is very difficult to compress an epic into an epigram because he has such a great personality. And also, you know that he was a law teacher, and he also wrote a wonderful book on mercantile law. And that book was one of the most favorite books in those days in 1960s and 70s. So, and I'm very happy to invite our Sri D.S.N.L.U. Garu, needs no introduction. And because he's son of the soil, and he has a third generation of advocates in his family. and his father, late Sri D.V. Subbarao Garu. He was the third generation and a distinguished lawyer, leading advocate of reputation in the city of Visakhapatnam and also in the state of Andhra Pradesh. And Sri D.V. Subbarao Garu. And Subbarao Garu, he used to visit Andhra University to visit my guide, Professor K. Gupteshwar Garu. And our Legal Services Authority Act was came into force in the year 1987. If I remember correctly, it was in 1985, a sort of Lok Adalat was arranged in the district court. Much before, it was only it happened due to the visionary of Sri D.V. Subbarao Garu, and we were the students. And what the changes that are going to take place in future, he visualized, and out of court settlements, and we are not much aware of what is happening in the courts. We are LLM students, and my guide, Professor K. Gupteshwar, and we used to discuss a couple of times. So we are fortunate for an illustrious father. We have an eminent son and judge. And D.V. Subbarao Garu, he was holding positions as Chairman Bar Council of India, Mayor Visakhapatnam. Today, what is Visakhapatnam? It was the contribution of Sri D.V. Subbarao Garu, being the first mayor. Otherwise, because I know Visakhapatnam since 1980s, and if we had to write the history of Visakhapatnam before D.V. Subbarao Garu and after D.V. Subbarao Garu, we had to. And our Justice Swamiyajulu Garu practiced law in Mufsal town, in the Mufsal area, that is in Visakhapatnam. It is a very, very, very rare event. Normally, when the advocates, they are elevated to the High Court, they will be elevated from the bar. Bar means the High Court bar, not from the Mufsal bar, unless the person is extremely eminent and who has impeccable integrity and command on law and command on the proceedings. So we have such legal luminaries, Sri D.V. S.S. Swamiyajulu Garu. Today he is graced the occasion and he is delivering the lecture. And to say about even D.V. S.S. Swamiyajulu Garu, there are so many things. But I could not resist at least to say a couple of things. Because in recent times, you might have observed, he was instrumental in delivering many landmark judgments. And particularly, the judgments in Udattav, Suresh and versus State of Andhra Pradesh and others, the judgment which was pronounced by the High Court very recently. So in the light of this judgment, what Honorable Justice D.V.S. Swamiyajulu Garu has touched the subject, it is a very, very common area. That is, police, they will bring someone and he will be branded as a rowdy, and a rowdy sheet will be opened. When once the rowdy sheet is opened, maybe a criminal or maybe an innocent person, maybe a teacher, maybe a doctor, whosoever may be. But it will be a stigma on the person, and in one way, it would be the moral assassination of the character, and the society will start looking at such person differently. So, in the light of that judgment, in the light of Amaravati judgment, and there are so many other judgments, so I conceive, Dr. Sir, I have already stated Dr. D.V.S. Swamiyajulu Garu. So there is a provision, and hope that you may join for research course for PhD. So I conceive Justice Swamiyajulu Garu not as one with a flaming sword, with an angel, with a lily, which wins the hearts of with a human touch. Because in him there is essential sweetness, that is his strength. There is essential wisdom, That is part of his clarity of vision, integrity and commitment to human rights made him a people's judge, a law. And when I read that judgment, it reminded me the judgments of Justice V.R. Krishna Iyer. V.R. Krishna Iyer also, he was the people's judge and he has very humane touch, whether it is workers' problems or whether it is the problems of women or children. And I consider and who may consider, because of his approach to the human rights issues in the Supreme Court. Sorry if you don't mind, we may call you as Krishna Iyer of Justice of Andhra Pradesh. And apart from his love for human rights, I don't say that it's a delicious irony, may not be an irony, but he never compromised with discipline and integrity that made Justice DSNLU Garu a gentleman judge. And with these few words, because still I have to leave something to my students who are anxious to introduce Justice Soumyajulu Garu. So we are today, sir, we are very much blessed with your presence, and definitely this lecture is going to be an enriching lecture to all the faculty and to the students and to the distinguished guests and the judicial officers. Thank you very much for giving me this opportunity. Thank you.
Thank you, sir, for giving us glimpses about the dignitaries. Since the dignitaries have taken out their precious time from their busy schedules, I would like our Honorable Vice Chancellor, sir, to please felicitate the dignitaries with small mementos of remembrance. With this, let us begin the afternoon with a short introduction on former honorable judges of the High Court of Andhra Pradesh. I would now like to call upon Ms. Siddhika to introduce Justice E.Venkatesam, Sri Eshwara Lakshmi Narsingha Rao, and Sri Ambibati Simachalam for the same.
Beginning with Honorable former Judge Justice E.Venkatesam Venkatesam, he was born on 9th May 1908 to Sri Eshwara Bhagirata Rao Garu, a leading lawyer of his times, and Srimati Eshwara Lakshmi Narasimha Garu. He studied up SSLC in the CBM High School, Visakhapatnam. He was the winner of the John Hay Scholarship of that school in 1922. Subsequently, he studied his intermediate class from Mrs. AVN College, Visakhapatnam, and BA class from MR College, Vizagaram. He obtained his BA degree of the Andhra University in 1927. Later, he joined the Law College Madras and passed the BL examination in 1929. He joined the bar at the Visakhapatnam in 1929. He passed the ML degree examination of the Madras in 1934. Enrolled as an advocate of the Madras High Court in September 1936, he practiced in the courts of Visakhapatnam District, Madras High Court of Andhra Pradesh, and also worked as the member of Board of Examiners. He was also a part-time lecturer at Andhra University Law College, Visakhapatnam, and Madras University Law College, Madras, from 1942 to 1950. Justice E.Venkatesam was appointed as an additional judge of High Court of Andhra Pradesh from 1961 and as a permanent judge from 1964. He retired in the year 1970 and was later appointed a member of Narmada Water Disputes Tribunal in 1970. Justice E. Venkatesam was the author of Handbook on Mercantile Law and Handbook on Contracts and Negotiable Instruments. He passed away on March 22, 1987. Sri Eswara Lakshmi Narasimha Rao was born in December 1897 in Visakhapatnam. Being born in a big family of 10 children, he was called E.L.N. Garu by all. E.L.N. Garu was engaged in managing the reins of his big household after the early demise of his father. Alongside his family duties, he completed his Bachelor's of Law in 1921 and joined as an advocate in Madras High Court. He practiced in a number of courts and was raised to the rank of government pleader. Around 1935 to 1940, he resigned from the government job and started his own practice. He was a protector of justice for the poor and underprivileged. He used to move in cattle carts and horse carriages to the nook and corner of Orissa and Andhra Pradesh to assist the poor in securing justice and settling their cases. Owing to his determined, disciplined, and selfless behavior, he soon became famous and was the leading lawyer in the area. He even donated a lot of money to various charities and constructed a Shiva temple in Vizagaram district. E.L.N. Garu was indeed a thorough gentleman who excelled both in his career and at his family front. Lastly, Sri Ambatipudi Simhachalam Garu was born in 1897. He was curious about the field of law since his childhood days. After completing his BA at Maharaja's College, Vizagaram, and BA at Madras Law College, he started his law practice at Berhampur. Simhachalam Garu, through his hard work, rose to great heights in his career as a lawyer within a short span of 15 years. He was the youngest criminal lawyer to be successful in the Madras presidency. One of the important cases he won was the double murder case. The most notable achievement in his career as a lawyer was his victory in a contempt case filed by him against Honorable Justice Humes, after which Justice Humes left India. This contempt case has earned him great name and fame. Sri Simhachalam Garu was an Indian jurist, philanthropist, political leader, social reformer, anti-colonial nationalist. He was a hard-working, sincere, and honest lawyer, strictly adhering to Satyam and Dharma. He was an ardent lover of classical music and was a devotee of Lord Sri Krishna. He was one of the founders of Sanatana Dharma Samajam at Berhampur. After achieving laurels in both professional and personal life, he passed away at the young age of 39 in 1936. Thank you.
Thank you, Siddhika, for reminding us of the efforts of former judges. Keeping this in mind, I would like to request our Honorable Guest of Honor, Mr. Malik Pucha, to address the gathering.
happen. That's what happened. Yeah.
Thank you all. Thank you, Sudhir, Sahiti, Dayanandamurthy garu, Surya Prakash garu, and all my cousins, first cousins and families. Second generation of Easwaras, Uma, Srinivas, Murali, and then from Ambadpudi side, Murali, and very much fun, sorry. Thanks a lot. And then our big family, Easwaras, Puchas, Durvasalas, Mamitapati. Sorry, I forgot my elder brother, Mamitapati, Panurao. Perhaps this is the biggest academic and family event that I may address. Pardon me if I break down. Easwara family is known for that emotional outburst. This lecture and gold medals were conceived in Bandhu Preeti, love of family, and Bandhu Prema, affection of the family, and to honor the people who made profound impact on you. Let me elaborate. My mother is the second daughter in the family of 5 Easwara brothers and 5 sisters. Our Padmamaya, Lakshmi Narasimha, Easwara Lakshmi Narasimha, was about 20 when my maternal grandfather, Bhagiradarao Garu, passed away in 1988 due to Spanish flu, similar to the COVID-19, and he took responsibility to raise the family. So we were very, very close. Let me give you an instance of Padmamaya's love for me. It was about June of 1951 or 52 in Guntur. I grew up in Guntur. Banu was also there too. Padmamaya and family came, and at that time, the tendency of a young kid is don't go, stay for one more day. And that's what I did. And then at that time, some of you may not remember the pull rickshaws, నడిచేవాళ్ళు అందరూ వచ్చారు స్టేషన్కి వెళ్ళడానికి సామాన్ కూడా పెట్టారు అండ్ Padmamaya asked me, మల్లికార్జున వెళ్ళబట్టావా మామయ్య వద్దు అన్నారు సామాన్లు అంతా లోపలికి తీసుకుపోయారు బాడుకుండారు కాబట్టి we went through Guntur ring road. That's the affection for a nephew. That's Padmamaya. And then in the case of E.Venkatesam, as some of you know, Andhra High Court used to be in Guntur in 54 to 56. And the courts generally closed by around March 31st. So they all went, and Maya was writing perhaps the second edition of the mercantile law during the trip to Madras. But he had a court case in around second week of April of 1956. He came over there, కోర్ట్ అయిపోయిన తర్వాత గుంటూరుకి మా ఇంటికి వచ్చాడు. వచ్చి మావయ్య అడిగాడు, మల్లికార్జున ఏం చేస్తున్నావు? And I was a 13, 14-year-old kid. ఏమంటే మావయ్య ఏదో వరల్డ్ బిల్డింగ్ అది చేస్తున్నాం, తర్వాత ఏదో అఫ్కోర్స్ సాయంకాలం పూట ఏదో క్రికెట్ ఆడతాను అనుకుంటున్నాను. దాన్ని మెడ్రాస్కి ఎప్పుడు వెళ్ళామని అడిగాను. And my third sister was married to Chavalis, and they used to live in Guntur in Madras. So నేను మా అమ్మతో పాటు went over there. So maybe I went in 48, మావయ్య నువ్వు మెడ్రాస్ చూడాలి, నాతో పాటు రా. At that time, there used to be a bogie from Guntur to Tenali, and that used to get attached to Madras Mail at Tenali. So all this discussion was happening around 4 o'clock in the evening. And then నేను బావగారికి అక్కడికి చెప్తాను, నువ్వు రా. And then I went. Next day, Uma's father and Chinna Venkati, second son, they came to pick me up in Maya at Madras Central. And then, so he told my third cousin, Ishwara Lakshmi Singh Rao, Venkatesam named his third son after my eldest uncle. That's the kind of respect they had. So he told my cousin, Narsingh, Mallikarjun Kanta Madras Chubinchu. So every day around, they used to be in Adayar. And so every 4 o'clock, every evening around 4 o'clock or 4:30, we used to go. We went to High Court, museums. And at that time, the LIC building was new, beach and all of that. And one of those days, we walked from Adayar to Guindy Engineering College and AC College of Technology. And my eldest brother, Pucha Purnananda Venkatesam Shastri, he studied in Guindy Engineering College in 1937 to 41, electrical engineering. He was the university first, gold medalist, but we lost him. August 17th, 1941. Uma, you were mentioning, Maya used to have a diary every year. He black border, August 7th, 1941. In 42, I was born. And so my father chose to give me Subramanyam, my eldest brother's name. So because of that, then when I was walking around in Guindy and AC College of Technology in April or May of 1956, that's when I got the idea, why not I study around this academic arena. Bingo, I was in the first batch of IIT Madras. Maya gave me that vision. So he changed the entire professional career of me. And as I call it, it was basically a random access of love. I'm a nephew, I'm not his son. But even then, he wanted to make sure that I also progress well. That is Venkatesam. So basically what I'm talking about, the Bandhu Preeti and Bandhu Prema of Ishvara's my parents and everybody else in the Isra families. They were the root cause of all of that. One thing that I wanted to make this event is to celebrate the Bandhu Preeti and the Bandhu Prema that my uncles, aunts, my parents, and everybody else gave it to us when we were growing up. The very fact my cousins and all of that came here shows the depth of that love. So with the righteous thoughts and the depth of love, you can achieve anything. So I want the younger generation to know that with the appropriate quality of love and righteous thought, you can overcome anything. JFK said, we choose to go to the moon not because it is easy, but because it is hard. Even for this, without going with any of these things, to make it happen, I went through, because this thought, I had it for quite some time. And thanks to Samayazalu, he has been helping me for the last 4 or 5 years, plus I've been bugging, and also as Sarpakar said. And initially, sir, Padmaya told me the advocate leaders of Visakhapatnam are Iswaras, Durvasalas, Atalas, Nishtala, and plus. And I wanted to get all those 4 or 5 families to celebrate that. Because there are some, unfortunately, actually, and then grandfather, he was a public prosecutor also at 50. I did visit with him in January 1980. So basically what I'm saying is the advocates of Visakhapatnam, they made a lot of name, and I'm not surprised that Subbarao Garu and then Samayazalu are leading that area. And then there's also one more thing I wanted to say, just to give some perspective. Venkatesam was born in 1908. My grandfather was somewhat worried when Venkatesam was ill sometime in 1912 or 1913 or so. Then my father, he used to have the horoscopes and all of that. Then he told, Bhagidrav Pantul Garu, Miremi Avadi Otande. Venkatesam will become a High Court judge. He predicted in 2012 or 2013. And then Maya became a judge in 1961. So, Samayazalu, even though I don't have the power of my father's astrological thing, I predict he will become a Supreme Court judge, one of these. So, thanks a lot, ladies and gentlemen. What I really want, expand your vision. You are not defined by the small things. Have your thought. Sky is the limit. You can do whatever you want. But I think, and also the other thing that I want to say is, the preserve Bandhu Preeti and Bandhu Prema. That is most important. The reason I am here is because of Venkatesam. He gave me the vision. And also my Padmaya. And also I need to say something about my Simhachalan Tatagaru. He is my wife's grandfather. And he passed away at a very young age, around 40. And so he was a very successful leading criminal lawyer from Parampuram. And I was told, of course, my father-in-law was only around 17 or 18 when Simhachalan Garu passed away. I was told that when he passed away, he had about 40,000 rupees underneath his pillow, because at those times, people do not want to believe in the banks. The reason I wanted to do it, even though I married a Ambadiputi, Audabodu, my wife, Pasata Lakshmi, she passed away about 7 years ago. The house that we bought in 97 or 98 had some seed money from Simhachalamgara. We sold that house finally last year in the Lawson's Bay Colony area. Then what I thought is, since I'm doing something at that time, I did not know what the heck I'm going to do. Since I'm doing something for my Kadamaya and Venkatesamaya, I wanted to do something from Tatagari, even though I don't know him well. And also it so happened, Kadamaya and Simhachalangaru were the classmates at Madras Law College. So when my father-in-law was there, Padmaya came for my wedding, then my brother was introducing them. Then Padmaya asked, Simhachalangaru came out, he was asking my father-in-law, then he told the relationship. So what I thought is, the two leading lawyers of Visakhapatnam, plus Barampur. At that time, Barampur is part of the Madras presidency, all of that. Now it is a separate state. So I thought I would do and honor all three of them, and then we settled our financial books this morning so that everything is fully funded and get go. Thanks a lot. Appreciate it.
Thank you, sir, for letting us into your historical background and for those kind words. With this, I would like to call upon Ms. Siddhika to introduce the chief guest of the afternoon, Honorable Justice Mr. Sumayajalu.
Justice D.V.S.S. Somayajalu, sir, was born in 1961 in family of lawyers. Justice Somayajalu did his LLB from Andhra University, Visakhapatnam, and was enrolled as an advocate on the roll of Bar Council of Andhra Pradesh. He practiced in courts of the Visakhapatnam and dealt with all kinds of cases, specialized in civil, commercial, and arbitration matters. He had appeared before erudite legal luminaries of national and international eminence in arbitrations all over the world and abroad. Obviously, sorry. He has been the president of the Bar Association, Visakhapatnam, president of AP Cricket Association, member of legal committee of the Board of Cricket Control, and also acted as an ambassador of Swachh Bharat for Visakhapatnam. He is the first advocate from Mufassal Bar in AP to be directly elevated as a judge of High Court. He was sworn in as Judge of High Court of Judicature at Hyderabad for State of Telangana and State of Andhra Pradesh in 2017. Justice Somayajalu sir has pronounced many landmark judgments. One such I would like to mention is the case of C.V. Ramani vs. State of AP 2022, wherein it was stated by him that when the rules of natural justice are flouted, the existence of an alternative remedy is not material. We welcome you, sir. We are honored to have you here. Thank you.
The President of the meeting, the Honorable Vice Chancellor, my distinguished uncle, Sri Malek Pucha, and everybody who has gathered here today. Good afternoon. The problem with these introductions is they raise the anticipation. I thank you, young lady, and the Vice Chancellor for the introduction. I hope I can live up to what is expected of me. I am both delighted and honored to be here. Honored that I am called upon to speak in the first endowment lecture established on behalf of Justice E.Venkatesam. To those of you who have no idea, there is a connection and there is a reason why I was invited. I was the resident family member who is now a judge of the High Court. My grandfather was a brother, or rather, Justice Venkatesam Garu and Narasimha Garu were the siblings of my maternal grandfather. And that is one reason why I am here before you today. Of course, Mr. Malik Pucha is a man who's very tough to say no to him. I think the Vice Chancellor will also agree. Once he gets a bee in his bonnet, it's next to impossible to stop him. And for the last few years, he has been after us to establish this lecture, and it is with the respect that the family has for him that a sum of 22 lakhs has already been donated. Some more is on the way. And I am sure the students of this university will benefit from Mr. Malik Pucha. Although he appears to be a nice and a kindly looking gentleman, he is, as he rightly said, a first product of the IIT Madras. He worked in the National Space Agency, the NASA as we know it, part and parcel of the Challenger missions to the Boon, and he wears his plaudits and his accomplishments very lightly on his shoulder. A very, very distinguished scientist sitting in our midst who made it all possible because of his bandit treaty. I'm also happy that I'm addressing this gathering and I am paying homage to two distinguished trial court lawyers. I am, by myself, a trial court lawyer. My heart always beats for a trial court lawyer and for the subordinate judiciary. Both Justice Venkatesam Garu and Iswar Narasimha Garu were trial court lawyers who made a name for themselves. And even now, since the students of this university are there, it is my humble request to all of you to practice for a few years in the trial court before you migrate wherever you want to go. As a judge of the High Court of Andhra Pradesh, I have been noticing it is the lawyers who have had a grounding in the trial court who become excellent appellate court lawyers and original side lawyers of the Red Court. If you are good in your procedural codes, if you are good in your Evidence Act, you are good in your Penal Code, Contract Act, etc., you will become very, very successful High Court lawyers. This is my first-hand experience, which I am bringing to you now. I have said it elsewhere and I am going to say it till my last breath. Justice Wajifdar of the Punjab and Haryana High Court said this, and I repeat it wherever I speak. A trial court lawyer is an artist. An appellate court lawyer is an art critic. A trial court lawyer is an artist. An appellate court lawyer is just an art critic. It is the trial court lawyer who is the foundation of the entire judicial system. It is the trial court judge who is the foundation of the entire system. The entire edifice is built upon the trial court lawyer and the trial court judge. This is something I very proudly say, and I very proudly say it without fear of contradiction. I have spoken before many audiences which comprise the judges of the High Court, advocates of the High Court and the Supreme Court also. But without a fear of contradiction, I say it and I repeat it also. We are the foundation. This entire system is built on this foundation. Take any law journal that you want. Flip through the pages. It is 50 to 60% of the cases are cases originating from the trial court. What is your Ram Janmabhoomi case? It was filed in a court in UP to declare it. Of course, the Supreme Court made the final, but the foundation was laid by a trial court lawyer. So today, since there are many young lawyers in this audience, I propose to start with Donaghy versus Stevenson, your snail in a ginger beer case, and end with Nambi Narayan. Because he's an NASA scientist, I wanted to end with. Nambi Narayan, as you know, was a scientist. How many of you have seen the movie Rocketry? Madhavan's movie. I'm going to end with that. And I hope at the end of the day, you will realize the connection. Nambi Narayanan was a very reputed scientist in the ISRO, was accused of something which he did not commit. And ultimately, he was exonerated. And the Supreme Court awarded damages of 50 lakhs. That is a topic I want to touch upon today. This is a topic that I have chosen. In fact, I owe an apology to the great Soli Swarajji. I wanted to speak about judicial activism. The later half of the topic, Boon or Bane,
was from an article written by just the great jurist Soli Surarji. It was at the back of my head when my uncle asked him and the Vice Chancellor asked me what I was proposing to speak. I said judicial activism, Boon or Bane, but both of them being so quick on the uptake, used it and adopted it for the topic. I owe an apology to just the great jurist Soli. He used the phrase and I copied it. I hope he will not mind. I'm sure he didn't have a trademark for it or a patent, but yes. Now, if you are a subscriber to Bar and Bench, you would see that yesterday the law minister was talking of the very same thing. He says today the problem in India is judges are making law. Judges are not confining themselves to the boundaries that are prescribed, namely that their job is only to interpret the law and not to make the law. Yesterday, I think today morning in Bar and Bench, this was highlighted. This is a topic which has been pending, which will be pending, which will be current as long as the Indian judiciary exists. You cannot wish it away. Tomorrow, as most of you become leading lawyers, I'm sure one of you will be speaking about it because I'm confident the topic will not die. The question is, what is the role of a judge? What is he expected to do? What is this judicial activism that we are talking of? The traditional view, both I think Mr. Lakshmi Narasimha Rao garu and Venkatesam garu would subscribe to this view. Their view would be, as a judge, my role is to decide the law as it exists. What is the law? And I will only interpret the law. What the law as it exists it is my duty to interpret it. Therefore, I will be interpreting the law. The activist says, what is the purpose of the law? What is the law meant to achieve? If the law is silent, should I also remain silent? Or should I interpret the law in a manner that the purpose of the law is achieved? Should I be, if I may use a phrase which can hopefully connect to the younger audience, if I'm a referee, should I just blow the whistle and keep quiet? And after the ball comes back into play, should I just watch the game as it progresses? Or should I impose my will on the players when they're playing the game? This is an age-old conflict which has been worrying everybody and which is worrying us also today. If we want to go further into the topic, we should first pay homage to two great souls, Justice Koka Subbarao garu and Justice V.R. Krishnaiah. The Vice Chancellor was very kind enough to compare me with the great legendary jurist. I mean, that is one of the greatest compliments I'll resign tomorrow and rest assured on it, saying that I have been compared to the great man, so therefore I think I've achieved what I am set out to achieve in life. Both of these people, along with Justice P.N. Bhagwati, have made Indian law what it is, a proactive law. In fact, if you read Fali Nariman's book, since we have a NASA scientist here, Fali Nariman compares them to the pole stars. He compares them to these two stars in the Ursa Major. And in the Indian way of looking at it, this is what is known as the Saptarishi. He says in the stars which comprise the Ursa Major, the two guiding stars or the two pole stars are Justice V.R. Krishnaiah and Justice Koka Subbarao. This is the effect that they have left on the Indian judicial system. These are the two great stalwarts who have laid down the law, which you, me, and everybody in this room and the citizens of this country are beneficiaries of. In fact, his son, Justice Mr. Nariman's son, Rohington Nariman, in his book, Discordant Notes, calls Justice Koka Subbarao the guardian angel of the fundamental rights of our country. Because there are he calls four distinguished judges starting from Vivian Bose and said, these are the four horsemen of the apocalypse and of the Lord. He says, Justice Koka Subbarao is the guardian of the fundamental rights. It is not for nothing that these two great jurists and a judge have chanced upon and commented only about Koka Subbarao, despite the fact that we had so many judges. The reason will be very clear to you very, very soon. Now let us start with Donaghy versus Stevenson before we touch upon the Indian judiciary. Donaghy versus Stevenson is a judgment of 1932 appeal cases. Now, what was the case about? This lady went to a shop, she bought a bottle of ginger beer, and she found a dead snail in it. Most of you would have, those of you who attended the classes would have understood. Now, what has that got to do? Now, the person who sold the beer was held to have a duty to take care. Now, he manufactures the ginger beer in his factory. It goes to the wholesaler, it goes to the retailer, and then it reaches the ultimate consumer. If the law as it exists was interpreted in Donaghy versus Stevenson, can you visualize you do not even know who is going to buy the beer? You do not know when he is going to drink the ginger beer. You don't know whether it is going to be at a house for the next 6 months lying in a shelf and it can deteriorate in value or quality. Yet the appeal court in 1932 felt he had a duty to take care. It is not as if this argument was not advanced. That how long will you stretch my duty to take care? If he keeps that bottle of ginger beer in his house for about 8 months or 9 months or 1 year, allows it to be exposed to the sun and the breeze, does he still have a duty to take care? This was the issue that was falling before them. And this is what is said. The law applicable is the common law, though its principles are capable of application to meet new conditions not contemplated, yet by themselves they cannot be changed, nor can additions be made. This is the view of a traditional judge, that my job is to interpret the law as it exists. And new additions cannot be made is an argument that was advanced. And what happened ultimately? The cardinal principle of liability is that a party complained of should owe to the party complaining a duty to take care. The party complaining should be able to prove that he has suffered damages. They did not keep quiet. They allowed the damages action to succeed. Therefore, if this was a case of the tradition versus activism, in 1932 itself, a purposive interpretation was given to the concept of duty to take care. You look at a famous case of the Ratlam municipality. I don't know how many of you. Again, Justice V.R. Krishna. 1984 Supreme Court cases 162. This is a case of a drain overflowing in the Ratlam municipality. An innocuous action under 133 of the CRPC. We have 2 judicial officers sitting there. I don't think 133 CRPC would ever be invoked in their courts. Very rarely, if ever. And this case of a drain in Ratlam municipality reaches the Supreme Court. And to their good fortune, they had Justice Chinnappa Reddy and Justice V.R. Krishna sitting on the bench that day. What was the issue? A drain was overflowing. The poor people sitting in that village of municipality of Ratlam were using the drain. The rich neighborhood which is next door complained, saying that they are using it as an open latrine. Therefore, it should be removed. This was the innocuous issue that reached the Supreme Court of India. And as I said, to their good fortune, 2 distinguished jurists were there. And what did they do? They directed the municipality to remove the offending articles and gave further directions. 133 CRPC, as both of them bear testimony, will never be invoked before a court. The Supreme Court of India took upon itself to give further directions to the Ratlam municipality to remove the drain, to clear the drain, to improve the sanitary conditions. Strictly speaking, they would have been within their jurisdiction in saying that this is not our duty, this is the duty of the executive magistrate. We wash our hands of it, we don't want to interfere. But the Supreme Court did not do that. Supreme Court gave directions which percolated down the line. And what did the great Krishna say? Although these 2 codes, he's talking of the CRPC and the Indian Penal Code in 1980, these 2 codes are of ancient vintage. The new justice social orientation imparted to them by the Constitution of India makes it a remedial weapon of versatile use. Social justice is due to the people, and therefore the people must be able to trigger off the jurisdiction vested in them. The Indian Penal Code and the CRPC were commented as codes of ancient vintage, but yet they were interpreted in a manner that the urgent need is to focus on the ordinary man, one whom I say is the little man on the street. Neither of these just shirked from their responsibility. Both of them interpreted these vintage codes in such a way that they ended up giving directions to the municipality to remove the difficulty. Now, if you look at it from the traditional angle, it can be said that the judges exceeded their jurisdiction, overstepped their jurisdiction, and gave directions which were not contemplated either by the CRPC or by the IPC. But they looked at the common man, the ordinary man, the man on the street, and then they gave directions. The question is, can you fault it? The ultimate purpose of the courts is to render justice to the needy. If that purpose is achieved, can you, by taking this restricted view, say you are an activist, you overstepped your boundaries, you overstepped your jurisdiction? By today, your right to travel abroad. All of you want to apply for passports, all of you want to travel abroad. Everybody says that liberal interpretation of Article 21 has led to this, Maneka Gandhi and the earlier case. Where does Article 21 talk about a passport at all? No person shall be deprived of a life or liberty except by a process established by law. How are you reaping the benefit of this law? How are you reaping the benefit of this interpretation of Article 21 to travel abroad? Today, if a passport officer denies you a passport, a writ will be filed immediately next morning. Again, a case of purposive interpretation of Article 21, which says the right to travel abroad is a part of your umbrella of rights, which are called your right to live a life of dignity, live a life of freedom. What were these two cases? You know, Maneka Gandhi, as you all know, is the daughter-in-law of a well-known political family. Her passport was retained. And what is the case that when they said they questioned the action of the passport officer in retaining the passport? Yet the law that is laid down in Article 21 has been read into it, and today it is the bulwark of your cases in the High Court. This is the basis on which everybody argues cases. A right to be heard, a right for due process, a right that the procedure established by law should be fair. All of it was read into a case where a lady complained that my passport is being retained without reason. No, this is purposive interpretation which comes to your benefit, which inures to your benefit. Can you still argue and say the judges exceeded their jurisdiction? They could have simply decided whether the passport officer was within his rights under the Passport Act and denying the passport and kept quiet. That would have been a proper interpretation of the law. But today, this generation and the next generation to come, or the generations to come in the future, are reaping the benefit of this, what is called an activist approach. So therefore, is this a boon or a bane is the conclusion you will have to reach. Two of these cases, 67 Supreme Court, 1836, and Maneka Gandhi, both were cases where the passport officer went forward and denied the passport, yet it was, then you look at your right to receive medical aid in a hospital. Suppose you are involved in a scooter accident. The old days was, we had what was called the MLC, or a medico-legal case. Whenever there was an accident, doctors refused to treat the patient. Even if the patient is critical in a serious road accident, bleeding and likely to die, they were so scared of the police system, they would not treat the patient. Is this correct? If you were the patient and you were the injured in the accident, you will raise hell and say, I demand treatment. But you were denied the treatment. Ultimately, it again took the Supreme Court to say, doctors have a duty to first treat the patient and then register the MLC, do the rest of it. This is Pandit Paramananda Katra, 89-4 SCC. The Supreme Court took upon itself the duty to pronounce the law and tell the entire public of this country, and the doctors in particular, that if a patient comes to you, your primary duty is to treat the patient first. Forget about the MLC case, etc. Again, the Supreme Court, in a way, overstepped its boundaries and laid down the law and said, the doctors have a duty to first treat the patient who comes to them, whatever be the reason, whether he is stabbed, whether he is a subject matter of a motor vehicle accident, or he is drunk and he was driving and caused the accident by himself. Please don't wait for all of that. First, treat the treat. Then all the ladies in this room are, now that you are aware of it is a study that many of the law colleges are doing, sexual harassment at workplace. All the ladies, all the women who are working have faced this in one way or the other somewhere in their careers. Ultimately, it again took the Supreme Court to lay down the law in an area where no law existed. Sexual harassment at workplace, difficulties that women were facing in the workplace was something that everybody knew it existed. Nobody had the courage to bell the can. And it was the Supreme Court in the case of Vishaka in 1997 and laid down guidelines by itself, defined what is harassment, told the employers how to create a channel for the women to complain in case they were harassed at a workplace. And in 1997, the Supreme Court laid down the law and said this is the law which would apply because of the vacuum that exists. But the act only came into force in 2013. 97 to 2013, this judgment was the law of the land. Now, if a woman was accused, was the, let us say, a victim of sexual harassment at workplace, something like, a boss teasing her by sending her pornographic material, sending her lewd messages, etc. Till then, the law was not defined. What is harassment was not even defined. So if a woman in 95 or 96 actually made a complaint, she only had to rely upon the offences in the Indian Penal Code and say, outraging my modesty through a cell phone. I'm sure both the magistrates sitting here would have struck the case down saying that it doesn't meet the law as it is laid down. But her modesty was in fact outraged. And somebody sends a lewd message, a pornographically laced message or something like that. Again, the Supreme Court stepped in, created a law where none existed. A judicial vacuum was filled up. We laid down what is harassment, laid down the procedure for complaints. Now, is this activism or is this overstepping the boundaries? And ultimately, in 2013, virtually what is written in the judgment has been incorporated into the Act. It becomes the law of the land. Police Complaints Authority. About a month ago, when I was sitting in the bench, the state of AP finally said we are constituting a Police Complaints Authority and directed that a bill be dismissed. Now, this judgment was in 2006, 8 Supreme Court cases, page 1, Prakash Singh and others, where the policies were exceeded, there were police excesses. A person did not have a remedy. In 2006, the Supreme Court recommended that a police excesses authority should be created at the state level and the district level. And this came into being now, in 2022. So for the last 16 years, despite the authoritative pronouncement of the Supreme Court, there is no authority for a person, for a citizen to complain. Now, if the Supreme Court took upon itself a need to create an authority where none existed, where a citizen is given an access to an authority where none existed, can it be called activism? Or is this judicial interpretation that arises or meets the need of the hour? This is a question which we should all ask ourselves. The traditional view would be the Supreme Court had no duty to create an authority where none existed. It is for the legislature to frame the law. Your job is just to interpret the law. But when a vacuum exists, when a need exists, when there is a need to step in quickly, and the Supreme Court does that, can it be said that this is judicial activism or judicial overreach? This is something that all of you, as students of law, should think. And when I mean students of law, I mean everybody in this room. I've said this earlier on this very same stage, and I say it now. For 5 years, you're a law student. The rest of your life, when you're practicing law or you're connected with law, you're a student of law. All of us are students of law. We will continue to be students of law. This is something that you should all think it over. Is this judicial activism or is this necessary? If there was no remedy, if there was no solution in sight, if you were injured in an accident, you go to a hospital and the doctor refuses to treat you, saying that an MLC has to be registered till the constable comes and records your statement and I'm not going to treat you. What happens if you're losing blood? You're likely to go into a shock. Your primary right is to get treatment. And this is what the Supreme Court did. In Paramananda Katra's decision, they gave a direction to all the doctors. Please treat the patient first. It is a part of their oath, the Hippocratic oath that they take. The primary duty is to treat the patient. But the system was drawing them back. They were not treating the patient, giving him the emergency medical aid that he deserves. Yet it took the Supreme Court guts to pronounced this judgment. They faced criticism, but in my opinion, the criticism is worth it. When I was also talking to you, I started that I would introduce the topic by starting with Donaghy versus Stevenson and ending with Nambi Narayan. This is a topic which is very close to the rowdy sheets case that I had the good opportunity of dealing with. Now look at these rowdy sheets. Rowdy sheets are opened by the police whenever they feel that man is a habitual offender. The rowdy sheet is continued. The law on the subject told the police how to act in these circumstances. They have to review the cases. They have to see the track record of the person. There is a case of a person who was accused of stealing a bicycle. The case ended in an acquittal. That young man applied for a passport. Passport was denied in the criminal antecedent verification on the ground that a rowdy sheet is still pending. There are cases where minor criminal offences which are compounded in the Lok Adalat. Compromise decrees were recorded. So he is no longer an accused, yet the rowdy sheet continues. He is unable to apply for a government job because police antecedent verification reveals that he is a rowdy sheeter. Rowdy sheets, according to the settled law, can only be opened if he is a habitual offender. A simple grammatical interpretation of a habitual offender means somebody who is used to and continuously commits offences. I am not going into the pure definition and the various acts. Simple English. Habitual means somebody who is used to a life of crime. Even though he commits a single crime, let us say in a fit of passion. Crimes can occur in passion, crimes can occur with premeditated mind. Suppose somebody is, let us say, coming into your house, trying to attack your sister. You take up a stick and beat him. That is also a crime, but it is a crime committed in the heat of the moment. Can you be called a habitual offender for that? I mean, the law was declared by this AP High Court and other high courts more than 2-3 decades ago, but still these rowdy sheets were being opened. The question in these cases is, did I commit a mistake in overstepping, or did I commit a mistake within the boundaries? I mean, that's a judgment I pronounce. I can't justify it, but the thought process that went into this was this. Should the judges be silent spectators, or should they take a more active role? You look at this police exercise itself. Today, Nambi Narayan, the character that Madhavan played in his movie Rocketry, was ultimately awarded damages of 50 lakh rupees because he was exonerated totally. The case against him was found to be false. The case registered under the Official Secrets Act, espionage, etc. were hurled against him. His whole family was subjected to mental and physical torture. They were all exonerated and ultimately 50 lakhs was awarded. Now, which branch of law, civil law, permits the Supreme Court to award these damages? There is no law. Just because a man is exonerated honorably, acquitted honorably, on what basis did the Supreme Court award its 50 lakhs? If you trace the growth of the law in this particular aspect, you will realize that the Supreme Court did an extraordinary job in creating a new branch of jurisprudence which all of you will be able to use in your careers. I'll just take you briefly through that. This is one of my pet topics, so therefore I have a lot of case law. I'm not proposing to read all of that. I'll just take you through the growth. The senior citizens in this room will recollect the Bhagalpur bindings of 1981. Younger generation would not know. In a remote place in Bihar, the police poured acid into people's eyes and blinded them. This was known as the famous Bhagalpur blinding case. The question was, when they claimed for damages, there was no law that could permit the court to award damages. At that point of time, the Supreme Court started looking into this area and said we should forge new tools, look at new remedies to address issues like this that will arise in the future. The first of these cases that I'd like to bring to your notice, I'll just briefly touch the fact. Rudul Shah versus State of Bihar, 83-4 Supreme Court cases, page 141. The students of law, the law students, please today, if you have the time after this endowment lecture, after your lunch and before your afternoon siesta, go and look in. 83-4 Supreme Court cases, page 141. This is a case where a person was acquitted in a court on 16th October 1982. I'm sorry, He was acquitted on June 3rd, 1968. On June 3rd, 1968, this gentleman was acquitted, but he was still kept in prison and not allowed to leave. Ultimately, the application was heard on November 22nd before the Supreme Court when a habeas corpus was paid. It was immediately submitted to the Supreme Court, sir, the detenue has been released, the habeas corpus has become infructuous. Please note the date, June 3rd, 1968, he was acquitted, but he was released in jail only in October, and the habeas corpus was filed in November. Technically, the Supreme Court was right in saying that by the date the petition came up for hearing, the detenue was released, the application has become infructuous. But the Supreme Court was shocked. Somebody who was acquitted in 1968 was still retained and detained till 1982. They did not wash their hands off and say this has become infructuous, case is dismissed. They went into the matter. And then they decided to start looking at awarding damages for unlawful acts. The right to compensation is some little palliative for the unlawful acts. Therefore, the state must repair the damage done by the officers to the petitioners. And Supreme Court would have been absolutely within the four boundaries of the law by saying by the date this came up for hearing, it has become infructuous. But they did not shirk from their responsibilities. They said, we have to award some damages, and started the process of awarding them. Neelabat Behera, another leading case on the subject. This is a complaint by a mother that her son was illegally detained, tortured in police custody. Again, a custodial death of a young man. And what did the Supreme Court do? A letter written on 14 September 1988 by Neelabat Behera was treated as a writ petition and taken up. From the mother's point of view, please imagine the anguish. A young man killed in police custody, illiterate people coming from interior India. She writes a simple letter, which is taken up as a writ petition, entertained, and orders are passed. Would you call this judicial activism, or would you call it, as there is a need, that this is judicial interpretation for the purpose of giving justice to the man on the street, the downtrodden, the poor, the humble? Supreme Court could have said, it is already over, he died, you file a civil suit, claim your damages, prove your damages. They would have been absolutely within their rights in coming to that conclusion. But the Supreme Court did not do that and said, the enforcement of the right in this case of every contravention must be possible in the constitutional scheme, the mode of redress being what is appropriate in the facts of the case. The remedy in public law has to be more readily available when invoked by the have-nots who are not possessed of the wherewithal for enforcement of their rights in private law, even though its exchange is to be tempered. I'll read that sentence again. This remedy in public law has to be more readily available when invoked by the have-nots who are not possessed of the wherewithal for enforcement of their rights. A poor mother, anguished by the loss of a grown-up son, writes a letter. This is taken up, enforced, and damages of 1,50,000. I'll come to that later. At least a beginning has been made. When the Supreme Court, in a way, overstepped its regular jurisdiction. It should have been a case of civil action for damages, proving the loss that has actually occurred. How long would it take this mother to prove it? I think even now she would have still been in the first appellate court, even if she had filed it in 1988 or 89. But the Supreme Court decided it has to provide some palliative remedy, some little recompense for the anguish of the mother, and awarded 1,50,000. Then you also the younger generation would be aware of the Upahar tragedy in Delhi. People went for a movie, I think it was a border movie, if I remember, border movie, which was playing 59 dead, 103 injured. Till recently, the owners were in and out of jail before the Supreme Court knocked it down with an iron hand and said, you have to go through your imprisonment. That's a different issue. This is a case again of the duty to take care. There are 5 or 6 players involved in this. the electricity board which permitted the electrical connections, the municipality corporation of Delhi which permitted the overseating, the manufacturer of the seats which caught fire, all of these were the players involved. The question was, what is the duty of care that the owner had to take care? It was an overcrowded hall. People were watching a popular movie. It caught fire. Some of them died due to the suffocation. So the contention, one of the contentions was, it is not a direct cause of the death. There was a stampede in which they panicked and therefore they died. All of these were, and here for the first time Justice Radhakrishnan came up with what is called a constitutional tort. Those of you who have the time, please go through this. The question of a constitutional tort is a concept that has been evolved by the Supreme Court. Again, the Supreme Court rose to the occasion, came to the end, awarded damages. In fact, the 59 patrons, Delhi Vidyut Board, Upahar Cinema, cars that were parked in the adjoining area were caught fire, burning oil from the cars came. These were all the defenses that were raised. We are not directly responsible for the death. The Supreme Court could have relegated them to the civil court and said, please establish your case there and claim your damages. I mean, judicial officers here, advocates here would also know, in motor accident cases, we use what is known as the multiplier method in awarding damages. We take the age, the income, and if the person dies, what is the probable income that he would have earned. So in a series of judgments, the Supreme Court laid down what is known as the multiplier method, a rough and ready method of calculating damages. So let us say you're 25 years old, you're earning about 1 lakh a month, and your anticipated lifespan is 70, what you would have earned. This principle from the motor accident claim cases was pressed into service here for calculating damages. In a way, it has judicial overreach. In a way, it is doing something which is not strictly sanctioned by the law. A branch of law which is developed in totally different circumstances, motor accident claims, was brought into this case, and the judges said, if this is possible, you can award damages. Use this as a method of calculation damages. Rini Johar was another case. I think those of you, this is again 2016-11 SCC 703. This is a problem most advocates face when they're dealing with the police and criminal case. A lawyer, in the course of her duty with her client, was almost arrested, thrown behind bars. I mean, many of the lawyers and the president of the Bar Association who's here will also agree. This is a problem which normally happens. When lawyers go to the police station, there are disturbances, there are arguments. But Rini Johar's case was a case where she was illegally detained. The court could have simply said, you go file a case, prove your case, then award, get your damages. But again, the Supreme Court interfered and awarded 5 lakhs because it was disturbing that a lawyer herself was facing something so bad. The last of these cases that I want to come to, Nambi Narayan. Nambi Narayan, as you know, Madhavan made him very popular. He was a scientist of the ISRO who was accused of, under the Official Secrets Act, of leaking secrets to a lady called Mariam, who was a Maldivian citizen or a Mauritian citizen, if I remember right. His whole family was thrown out on the streets. At the end of the day, it was found he was not at all guilty of leaking any secret whatsoever. For the first time, the Supreme Court awarded 50 lakh rupees as damages for the reputation, for loss of his honor, for illegal arrest, etc. If you go by the traditional principles of law, damages have to be proved strictly. Unless you sustain a loss, you cannot claim damages. Suppose you sustain 10 rupees loss, you are entitled to 10 rupees as a recompense because you have to be placed in the same position that money can place you. But Nambi Narayan was given 50 lakhs. The Supreme Court, in a way, overstepped its jurisdiction, if you look at it from the traditional point of view. But if you ask me personally, Supreme Court did the right thing. This is how the law has been developing. From Bhagalpur bindings, where they said we should forge new tools, find new ways of granting damages. In Nambi Narayan, if you look at it, one by one, step by step, little by little, Supreme Court has made a difference and brought it to a case where today, in a public law remedy, a citizen can seek redressal. If he was driven to a civil court, he would have had a very difficult time in proving the damages. How do you measure the reputation of a man? What is the monetary value that you can attach to a reputation of a man? What is the monetary value you can attach to a case of wrongful arrest, even if it's for one day? Somebody holding a high position in society, even if it's arrested for one day, the reputation is tarnished beyond repair. How do you assess it in monetary terms? If you go to a regular civil court, these are the issues that will arise. But the Supreme Court stepped, according to some, overstepped and created this branch. In the West, these are very well known, whether it's England or American system where my uncle Malik Pucha comes from. But in India, this is a nascent area, a growing area. There is no settled law. It is the activism of the court that is bringing us here. I'm not shirking away from talking about the flip side of it. Even today, the law minister said in a meeting, judges are exceeding their brief. Judges are deciding where courts are to be run. Who will run the BCCI? Who will be the next election of the Indian Olympic Association? How is it to be conducted? There are criticisms. I'm not saying no. There are criticism that public interest litigation has become publicity interested litigation. The courts are stepping into every area which is not there within their jurisdiction at all. But yes, I agree. They say that judges are becoming very publicity conscious. They want to see their name in the newspaper every morning. These are all the criticisms which are being leveled. It's a democracy. They are entitled to. Honest criticism of a judge or a judgment is always welcome. Because judges are also human. They are not super gods. In the Supreme Court, it is said it is supreme because it's the court of last resort. They are not supreme just because they are Supreme Court judge. Because it's the court of last resort, you don't have anything further, it is supreme. And they also say they are supreme but not infallible. And I always say this. The fact that you have a power of review from this court down to the Supreme Court indicates that the lawmakers realize you can make mistakes. That is why review is given. You have in Supreme Court, you have curative petitions, you have review petitions. At our level, we have reviews. The review indicates, yes, we are also human, we make mistakes. I'm not saying for a moment that the judges have not made mistakes or some of them may have got carried away. It's an individual thing. I don't want to comment further. But the fact remains when you weigh the criticism vis-a-vis the benefits, I am of the firm opinion that this sort of judicial activism, and maybe that's a wrong word to use, this sort of judicial approach is really needed. In a country like India, where we have our own brand of peculiar problems, unlike in the West, somebody should rise to the occasion. Vishaka is a beautiful example. Police Complaints Authority is a beautiful example. These are all cases where the Supreme Court stepped in, made the law and said, you please enforce. This is the law till you enact a law. They have not taken over the jurisdiction of the Parliament. Because a vacuum existed, because a void existed, which needed, and there is a problem which needed to be addressed immediately. They stepped in. There a woman, how did the Vishaka's case state? It talked of a rape of a woman in a village. But look at the ending. It benefited thousands and millions of working women throughout the country, leading to the enactment of it. So therefore, in conclusion, I would say this. This is not judicial activism. This is not judicial adventurism. This is a judicial necessity forced by the circumstances. The void that is there had to be filled up. It is not a case of anybody that the judgment is per se wrong. Nobody has ever said that the guidelines given in Vishaka are per se wrong and contrary to the law. The essential criticism is you overstepped your jurisdiction. You went into areas which are not meant for you in the division of powers under the Indian Constitution. But in my humble opinion, I leave it to the floor. You are also well-educated people sitting here. You can also judge it. But I would say this much. Unless and until this sort of proactive approach was taken, many of the problems that we have are not solved. If I have not touched upon any of the environmental issues, all you have to do is tap MC Mehta in the Google search and you'll see at least 4,000 to 5,000 times his name is referred. Delhi today is an environmental mess. There is fog, there is stubble burning, and for the past 10 to 20 years, the Supreme Court has been monitoring the pollution levels. It has phased out the diesel buses. It has brought in CNG buses. It is now bringing in electricity buses. All of this to improve the environment in Delhi so that the common man does not suffer. If the governments do not do it, is it wrong for the God to step in? Everybody recognizes that pollution is a serious issue in Delhi. Somebody is taking a stand. Somebody is taking a step forward. Somebody is sticking their neck out and saying, I'm going to do it. Why criticize them? If you can help them. Look at the tanneries in Kanpur. If you go into the environmental issue, all of us are reaping the benefit of these great men and women who have fought for their causes. Today we are in Bharat 4 or Diesel 4 or Bharat 4 or Bharat 5 emission standards, all because of activist people and activist judges. Therefore, your passport, today you cannot be denied your right to have a passport. You cannot be denied your right to go to a government hospital and ask for immediate treatment and an action. All of this is because of judgments that have made the law in an area where none existed. Therefore, with these words, ladies and gentlemen, I would conclude. A big thank you for all of you for being so patient. Thank you.
Thank you, sir, for those words. Judicial activism is indeed a judicial necessity, and to draw a line between interpretation and purposive interpretation is definitely something we need to reflect upon. With this, we have a short audio-visual on Justice E.Venkatesam, which highlights his achievements and life history.
Sorry, repair and much better.
My name is Lakshmi. I am the daughter of Justice E.Venkatesam Garu and the only surviving member among my parents' 4 children. Professor B.V. Ramanathan Garu, one of his students, wrote highly about my father in his book, Nenu Andhra Viswavidyalayamu, written in Telugu. He said my father came up the hard way as he was teaching law in Andhra University and simultaneously practicing in the High Court. He said my father was a knowledgeable lecturer, very dynamic, dignified, and an eloquent speaker with a sense of humor. He was held in high esteem by his students. Many of his students and juniors became judges and held high positions. He was very affectionate, caring, disciplined, and very meticulous. Though he was rising in his career, he lived a simple life and upheld high values till the end. He was generous and rendered financial and other help to his extended family. I had the honor and privilege of taking care of him during his last stage when we were in Delhi. Thanks for the opportunity to share my views.
E.Venkatesam garu, ఈశ్వర సత్యవతి గారు పెద్ద కోడలు ఈశ్వర సుందరలక్ష్మి. నేను నా పెళ్ళి 61లో పెళ్ళి అయింది. అయినప్పుడు అప్పటి నుంచి ఆయన పోయే వరకు ఇప్పటి వరకు ఆయన తలుచుకునే మా మామగారిని మా అత్తగారిని తలుచుకునే నడుస్తూ ఉన్నాను. కోడల్ని కూతురు కన్నా ఎక్కువ చూసుకున్నారు. ఇంత చేసుకున్న వాళ్ళని ఎక్కడ చూడలేదు. దేవుళ్ళని అనుకోండి, నేను వాళ్ళ లోపల ఇప్పటి వరకు వాళ్ళు చెప్పిన పద్ధతులు అవన్నీ ప్రకారమే నడుచుకుంటూ ఉన్నారు. ఎక్కువ చివరి వరకు నేను చేశానో లేదో కానీ వాళ్ళకి తృప్తిగానే చేసినట్టు అది భగవంతుడు నాకు శక్తి ఇచ్చాడు. అది చాలు నాకు సంతోషం. నమస్కారం.
అది అవసరం వచ్చినప్పుడు ఆయన అన్నీ చేసేసారు. అలా తగ్గిపోయింది పోవాలి. అవును ఆపలికే కానీ చాలా తగ్గిపోయింది. అటువంటి సాక్రిఫైస్ నాకు అందుకు వాళ్ళంటే అంత అలాగే ఇష్టం. ఇది బాగా పడ్డారు. పెళ్ళిళ్ళంటే ఆయనే చేసేవాళ్ళు. నేను అందరికీ ప్రశ్నలు ఏది వచ్చినా ఏ కార్యం వచ్చినా సరే అమ్మాయి అంటే మా అన్నయ్య చెప్పాలి. అన్నయ్య తప్పి ఎవరు
I have so many fond memories of my maternal uncle, Mr. Venkatesam, during his opportunity. I used to visit his house after my university time. It was new to Delhi, always needing assistance to set up his office at his residence. I was the first child of New Delhi on my mother's side of the family. It was really handled by the uncle. We are investigators, intellectual behavior, and we are the Indian families. We are very happy to visit them. We are very sorry to have this, but I am not I remember you with love and understanding. Yes, I remember you with yesterday presentation. The deal of my parents often speak with me. All I have is you.
Dr. Garu and Mainam Garu spent a lot of time and had so much interest in guiding me, in molding me, and making me a better person every day. And they really have put so much effort in during my childhood till I'm married. So you can imagine the number of years of effort, interest they have taken in order to put me in the right direction. So I do not have any words to express how much I owe them. I deeply pray to God to give me such opportunities so that, I can learn from people like Dr. Garu and Nainamma Garu.
Both Dr. Garu and Nainamma have guided us in each and every part of our life. There are many important 4 or mentioning now. One is education, second, etiquette, third, relationships, and work-life balance. ఇది తాతగారు నాయనమ్మ మాకే కాదు, వాళ్ళ చిల్డ్రన్ గ్రాండ్ చిల్డ్రన్కే కాదు, all relatives and friends ki kuda, they have shared this. We will definitely make you proud, both of you, what we are today.
In every respect, he was kindness personified, and one with a big heart and giving nature. I can think of 5 of his core values. First, honesty. He never wavered from being honest. Second, identity. He created his own identity. He was an avid reader and a great artist. Very few knew about this side of his personal life. He drew sketches of famous people such as Mahatma Gandhi, Bhagat Singh, M.S. Subbulakshmi, John F. Kennedy, and many others. Third, learning. We believe learning is a continuous process of life. Third, giving. There was never an incident I can recall where he did not extend his hand to give. Fifth, humble. He epitomized what it meant to be humble and grounded. Last but not the least, behind every successful man there is a woman. My grandmother was equally instrumental, and many times even more. They both showed their love, their affection through their deeds. He is my role model.
Hello everybody. I am Dr. Vikas, son of Boon. Father's acquaintance with him, with his maternal uncle, was very immense. He was very persistent to tell my father and my mother that we should have our own house. I'm living with my mother today in our own house. It is all this credit goes to him.
Obviously, the number of memories I have are not as much as everyone else. We moved to the United States in '74. They came and visited us in 1975, then we visited in India in 1977. So that's the last of the physical memories. But I think more importantly is what Father made me feel growing up. No matter who you spoke with, aunts, uncle, cousin, friends of the family, Venkatesam is synonymous with integrity. We all strive for his stamp of approval. And I'd like to think that that's how I live my life, in his footsteps, carrying the same sort of integrity that he carried through life.
I would now like to call upon all the members of the Venkatesam family to felicitate Malik sir and Somachlu sir.
My Simvachalam Gari Manavadu, Murali Mohan, and then Susila, they want to honor Swami Adilgaru, Justice Swami Adilgaru. So I just wanted to make it happen.
వాయనం పుచ్చుకుంటా వాయనం. Thanks, madam.
As they have said, okay, as some of you have said, I worked in NASA area, and I want to present this NASA photo frame to all the people who made it happen. First one is, of course, Justice Samyadru garu. నాకేమో స్వామియాజులు గారు కొడుకు వరుస అవుతారు. సో దెన్ ఐ థింక్ ఐ డిడ్ వాళ్ళ తాతగారి పేరేమో దూర్వాసులు శ్రీరామ శాస్త్రి గారి, if I remember. I think his name contains that. And then so Swamiyajulu, I think I just want to say something. I already said that as I was giving it. I think నేను అప్పుడే చెప్పాను కానీ, but I think I want to say it one more time. I want you, నేను ఉండకపోవచ్చు కానీ, but I want you to be the Supreme Court Justice. One of them. So, yo vaikam brahmano vedam amrutena amrutam purim tasmai brahma cha ayuh kirtim prajantatuhu. There are not that many times when a father can see their son become a justice. I know there are the current Supreme Court, I think judge, the nominee, I think he's going to be, but I think his father was a Supreme Court judge earlier. But I think me Tata garu, E.V. garu, now you in the Durvasra family are bringing a lot of fame and to the Iswara, Durvasra families and all of that. May God bless you in every way. Yeah. I know, I think about approximately 6 months ago or so, Swamiyajulu garu introduced me to Suryaprakash garu, and then I think I know he came to Detroit, US వచ్చినప్పుడు ఆయన కొంచెం బక్ చేశాను నేను. సో చేసి ఎలా చేయాలి, and then I called up when it was about 2 or 3 o'clock in the US time. Of course, it was okay in the India time. And then ఏది చేయాలి and all of that. And as you could imagine, trying to do with all 3 families and making sure we got 22 lakhs. We did make it this morning, and we reconciled all the accounts so that the institution has the money before this year. We got it done. Thank you. Yeah. నిన్న రాత్రి మేము గెస్ట్ హౌస్కి వచ్చిన దగ్గర నుంచి గెస్ట్ హౌస్ నుంచి మాతో పాటు ఉండి, అండ్ దెన్ అటు ఇటు ది లాజిస్టిక్స్ అన్నీనేమో Dayananda Murthy has been helping me because, and also I think, sorry, English. Yeah, I think he's from Karnataka, even though he knows Telugu, but I think I have been using too much of Telugu, so I just want to make sure I speak to him in English in this presentation ceremony. Thanks a lot, all three of you. You helped make this happen, and I think my joy knows no. Appreciate it. Damodar Sanjeevaya, National Law.
With this, we come to an end of the endowment lecture. To propose the word of thanks, I would like to call upon our respected academic director, Mr. Dayananda Murthy, sir.
Very good afternoon to all the technicians on the dais, faculty members and supporting staff and my dear students. I believe after seeing this, I am bound to say, and I believe that even our Vice Chancellor was expressing the same thing, today what family bonding is and how it is necessary that one will respect the other family member. I think when we see this to the present world where every relationship becoming commercial, whether it's a family life or a professional life, even a friendship is becoming commercial, I think this family has shown us how they can be together even after almost around 80 to 90 years. When we see the videos also, we can come to know how bonding, how together they are. Basically, I think we feel proud of your families, ma'am and sir. Thank you so much for being with us. And one more positive thing which has happened is this endowment lecture. We have started with this endowment lecture. I believe all the family members have contributed to this university, almost around 22 lakh rupees. One part of it is in the name of Justice Venkatesam, it's coming to around 12 lakh rupees. One endowment lecture and a gold medal. Gold medal will be for jurisprudence. Okay? I'll come to that. I'll come. Venkatesam. Okay. Venkatesam is for commercial law because he has written a book on mercantile law. Sir told that. Okay, fine. Sorry, sir. Then next is one more gold medal in once again instituted by in the name of Ishwara Lakshmi Narasingha Rao. One is for commercial law. Criminal law, and the Ambati Simhachalam medal is for criminal law. So first year, second year, third year students, get ready. If you top, you'll be getting any with the gold medal here. But be careful, you should not have a back. Okay? If you have a back, you lose the chance of getting this gold medal, whatever has been identified here. Thank you so much for contributing to the institution. I believe we will take the responsibility of making this education institution better in this case. With this, I come to the last part of the thing, which is the word of thanks. First and foremost, I thank Professor Surya Prakash for getting this opportunity of introducing a good family and ultimately giving contributions to this university in the large scale for the first time, and also in allowing us to organize this particular endowment lecture. Thank you very much, sir. I also thank Shri Malik Pucha, who is the person who is behind all these things. With all the family members together, sir, we thank all of you together here. And one and only one, I should thank Honorable Mr. Justice Soumyajulu, sir, for a wonderful lecture as usual, right? No compromise on that. Thank you so much, sir, for addressing and telling our students how important it is to go for a trial court practice, as well as how important it is for a judge to interpret the law and ultimately judicial necessity as such. I also thank Shri Bhanurao sir. I also thank Srinivas Dhruvasalu sir, honorable judges of the district and judicial officers of Visakhapatnam, Anakapalli and Vijayanagaram, members of the Bar Association. I think we have the president of the Bar Association, Vizag. Thank you, sir, for being with us. And all the professors of law schools and colleges, thank you for being with us. Then Ishwara Lakshmi Narasimharao, Ambati Simhachalam, and then for sponsoring this gold medals. Then we also thank Madhusudan Rao, sir, our registrar, sir. Then faculty members, supporting staff, print and electronic media, and last but not the least, my all dear students. Thank you, and I hope you have carried many things, many responsibilities here. With the conclusion, I want to say, don't be commercial in relationships, okay? Have the bonding and respect that value. The family value is the most important thing. That's the lesson we learned from this family, I believe. We all respect that. Thank you so much. Thank you.
Thank you, sir, for presenting the vote of thanks. Before we disperse for lunch, I would request each one of you to please rise for the national anthem. All the guests in Thailand to proceed to the conference hall of the ground floor for lunch.
నమస్తే మేడం.
Yes, sir. Yes, sir.
Thank you. ఇదేమో నేను చెప్తున్నాను అంత ఎస్కాసినట్టాను నీ చేతను నా చేతను మరొకడికి
Madam, come in. Please, all faculty members.
Okay. Yeah, let's go. Back the legs.
Please come, sir.